Uh, Good morning, everyone, and welcome to Cover Talk, Mills Reeve's series of 15-minute webinars focusing on key insurance and reinsurance coverage topics. My name is Andrew Tobin, and I specialise in insurance and reinsurance coverage disputes, and I'm a partner in Mills Reeve's London office. Today, I'll be discussing the insured's duties to disclose information to its insurers before the policy starts. That duty was previously known as the duty of good faith, but was recently revised, updated, and renamed as the duty of fair presentation, which is now to be found in the UK's Insurance Act of 2015. That new act and the new duty of fair presentation within it applies to all insurance and reinsurance contracts governed by English law, concluded after the 12th of August 2016. This week, I'll be looking at the ingredients of the duty of fair presentation. I should make clear that we are looking today at business insurance and not consumer insurance, to which special rules apply. Next week, my colleague Neil Howes will focus on the remedies that are available to insurers where the insured has not complied with the duty of fair presentation. Our Cover Talk series will then go on to consider many other topics that come up throughout the life of an insurance policy, including issues regarding premium, the roles of warranties, conditions precedent, exclusions, subrogation, and so on. In 15 minutes, there are limits to what we can cover, but if questions occur to you during the presentation, please do type them into the box, and I will try to deal with them during the second part of the session or follow up with you afterwards. 200 years ago, commercial insurance business consisted mostly of insuring ships and other risks around the globe about which the insurer, who was usually based in London or some other port city, would know nothing. The rules of ordinary contract law at that time operated on the basis that the parties had more or less equal bargaining power and that they should find out for themselves about the circumstances of the contracts they had entered into and run the contractual risks on that basis. However, those ordinary contractual rules didn't work well in the context of insurance due to the massive information imbalance between the parties. Typically, the insured would have had all of the facts about a ship or a voyage, whilst the insurer would have none. So, to redress the balance and to protect insurers from fraud, the courts created a special principle for insurance contracts, and that principle is that the insured owes a duty of good faith to insurers. That principle was first described in a fascinating 1766 case of Carter and Bohm, which, if there is time, I'm happy to discuss later. The duty of good faith developed in case law, but came to be encapsulated in the famous sections 18 and 20 of the Marine Insurance Act 1906, which has also been held to summarize the rules applying to non-marine insurance. I expect many of you are familiar with those rules. But to recap, Section 18 required that the insured must disclose to the insurer before the contract is concluded every material circumstance which it knows or ought to know, and that if it fails to do so, then the insurer may avoid the contract. I can see a couple of questions asking if there are slides coming in. This presentation will be without slides as an experiment, but if we get a lot of feedback that slides are requested, then we will do so in due course. But Section 18 requires that the insured must disclose to the insurer before the contract is concluded every material circumstance which it knows or ought to know, and that if it fails to do so, then the insurer may avoid the contract. Section 20 required that every material representation made by the insured or his agent to the insurers during the negotiations for the contract and before the contract is concluded must be true. If it's untrue, then the insurer may avoid the contract. So in other words, the duty boiled down to a duty to tell the insurer anything that it might need to know to assess the risk, and secondly, a related duty not to tell any fibs. If either of those duties were breached, even innocently, the insurer's only remedy was to avoid the entire contract of insurance. That meant treating the policy as if it never existed. Premium would be returned, no claims would be payable, and payment for any claims that had been paid before the breach was discovered would be repaid. So the duty of good faith was a very powerful, if rather blunt, instrument with which insurers could protect themselves. So fast forwarding now to the 21st century, the UK Law Commission carried out a review of insurance law generally and concluded that the duty of good faith needed reform because it was poorly understood. The duty was too onerous, especially on medium and large-sized companies. The requirement to disclose every material circumstance encouraged data dumping, obviously a new problem in light of technological advancements. It gave rise to too many disputes, and the single remedy of avoidance was too harsh in many cases. To address those problems, the Law Commission recommended reforming the duty of good faith in order to encourage more active engagement by insurers in the placement process, as opposed to being essentially passive, to encourage policyholders to organise and signpost their risk presentations in a clear and accessible way to prevent those data dumps, and to give guidance as to how the insured should prepare a fair presentation by undertaking a reasonable search for information and by giving examples of what types of information might be material. And finally, to clarify whose knowledge in the insured organisation needs to be disclosed. But on the other hand, the Law Commission, who had consulted widely, did not want to throw the baby out with the bathwater. Rather, it wanted to preserve the core duty of the insured to volunteer material information to the insurer, because they felt that saves time and effort and makes it easier to insure non-standard risks, which of course is the basis of much of the London market's practice. And so one of the main outcomes of the Law Commission's recommendations was the replacement of the duty of good faith and sections 18 and 20 of the Marine Insurance Act with a modernised duty to be known as the duty of fair presentation. Those recommendations were accepted by Parliament, and the duty of fair presentation is now spelled out in great detail in sections 3 to 8 of the Insurance Act, which I recommend you read if you want to study this further. So there is a lot that could be said on the new duty of fair presentation, but today I propose just to touch on 5 key features. Firstly, the new duty of presentation does not fundamentally change the burden of disclosure borne by the insured. In fact, the new duty repeats the language of Section 18 of the Marine Insurance Act by requiring the insured, before the policy is concluded, still to disclose every material circumstance which it knows or ought to know to the insurers. Similarly, the new duty of fair presentation repeats the effect of Section 20 of the Marine Insurance Act by requiring that a fair presentation is one in which every material representation as to a matter of fact is substantially correct. What is a, quote, material circumstance, end quote? Again, the new duty borrows language from the old law. A material circumstance is still defined as being one which would, quote, influence the judgment of a prudent insurer in determining whether to take the risk, and if so, on what terms. It's not possible to give an exhaustive list of what particular circumstances might be material or not. That's always a question for the court to consider in each case. And in reaching its decision, the courts have traditionally taken into account evidence from the actual underwriter expert underwriter, as well as having regard to examples from previous cases. But helpfully, the duty for the first time sets out in statute some examples of circumstance of circumstances that might be material, namely special or unusual facts relating to the risk, any particular concerns which led the insured to seek insurance cover for the risk, or anything which those concerned with the class of insurance and field of activity in question would generally understand as being something that should be dealt with in a fair presentation of risks of the type in question. So examples might be in property insurance, circumstances that render a building especially susceptible to loss due to its construction or threats of arson. In professional indemnity or other liability insurance, information that claims against the insured have been made or are likely. I once had a life insurance case about a murdered insured. We discovered that both of his business partners had been murdered and that he was under a death threat when the policy was taken out. So obviously that would have been a good example of particular concerns which had led the insured to take cover, and so on. There are hundreds of examples that one can think of. Secondly, the Act very helpfully clarifies whose knowledge must be disclosed, which is particularly useful now in the context of companies and big organisations. Essentially, what must be disclosed is the material information held by the, quote, senior management, end quote, in the insured, as well as those persons who are responsible for the insured's insurance. That will include the directors and risk managers, but may also include other individuals. It will also include the broker. The third major innovation in the law is that the new duty requires the insured to disclose information that should reasonably have been revealed by a reasonable search of information available to the insured. This is a brand new provision. Under the old law, there was no clear duty on insured to carry out the search. It is likely to lead to a good number of disputes on exactly what a reasonable search means. It could be a complex question because what is reasonable will vary in each case depending on many factors, such as the location of the information, the technology and size of organisation, and so on. But I think what we can say is that in a dispute, an insured who can prove that it has carried out a reasonable search for relevant information will be in a stronger position than an insured that has carried out no search at all, or has carried out a search but cannot prove it. Note that the duty to carry out a reasonable search extends also to an insured's agents, which will include its brokers. Fourthly, the duty now clarifies what does not need to be disclosed to an insurer, including circumstances that diminish the risk, circumstances that the insurer actually knows, what the insurer ought to know or is presumed to know, or is something as to which the insurer waives information. And the duty clarifies for the first time that the insurer's knowledge for these purposes is the knowledge of the actual underwriting team rather than that of the whole insurance company. What an insurer ought to know is the information that ought reasonably to have been passed on to him by someone in his organisation, or which is information that is, quote, held by the insurer and is readily available, end quote, to the relevant individual. One example might be, for example, a recent claims file that should be available to the underwriter. Fifthly and finally, the duty of fair presentation, a fair presentation must be one which, quote, makes the disclosure in a manner which would be reasonably accessible to a prudent insurer. This is a brand new requirement. The Law Commission was concerned that in the information age, insureds and their brokers might seek to disclose inconvenient information, but would bury it in a data dump on insurers so that it would not be read. The courts will have to interpret this rule, but they are likely to have regard to the Law Commission's view that this requirement is not primarily intended to limit the volume of information, but instead is about the need to structure, index, and signpost the information which is given. So obviously there is a significant role for brokers to play here in ensuring that their client's risk presentation not only contain all the material information, but that is also properly organised and presented. If the information presented to the insurers does contain all of the relevant information, but that's not presented in a fair and accessible way, then the duty of fair presentation will not have been complied with, and the insurer might be able to exercise its remedies. There are other features of the duty of fair presentation, which I'm happy to discuss afterwards. But I also wanted to add that many of the provisions in the Insurance Act apply as default provisions. If parties are unhappy with those rules, then there are ways of contracting out of certain aspects of it, subject to the transparency requirements set out in the Act, although that is a discussion for another day. Well, I said it would be 15 minutes. I think I'm 16 minutes. There is more that could be said. I hope I've been able to highlight some of the main ingredients. Next week, my colleague Neil Howes will discuss the new remedies that are available to insurers where the duty of fair presentation is breached. And that is an area in which dramatic changes to the law have taken place. Now, I think we have time for a couple of questions, and hopefully my colleague Matt Skipper has been keeping an eye on them for me.
Thanks, Andrew, and thanks to everyone for joining. We have had a couple of questions. So the first question is, does the Insurance Act place a greater burden on brokers to identify examples of material facts? I often come across brokers who fail to inquire details of financial history of directors, for example.
That is a good question. I think the main change, I don't think the burden is not to, the test of materiality has not changed. So the same sorts of information need to be disclosed. But what is new is that the insured and its brokers have now this extra duty, and it's a new duty to carry out a reasonable search. So to that extent, I think the burden is upon brokers. And as I said before, if information is not found, but is later discovered and said by an insurer to be material, then a question might arise as to whether the broker and the insured really did carry out a reasonable search for that information.
Okay, thank you. We have another question. You mentioned that an insured does not need to provide information if the insurer waives it. What does that mean?
Yes, so the obvious way in which an insurer can waive information is by simply saying, well, I don't need to know about this or that. But in fact, insurers often waive information by accident and without realizing it by asking questions, either orally or in a proposal form. For example, if an insurer asks if a fire alarm has been serviced in the last 2 years, it is taken to be waiving any information about the state of the fire alarm before 2 years. I had a case concerning a fraudulent robbery on a jeweller's. We discovered that the insured, at the time he took out the insurance, was on a charge for perverting the course of justice in connection with a murder. But the proposal form asked him only about convictions in the last 5 years. And he answered truthfully that he had no convictions in the last 5 years. Probably the question on that proposal form had waived the obligation on the insured to disclose the charge. So it does mean that questions and proposal forms need to be considered carefully.
Okay, thanks, Andrew. I've got some more questions coming through. Could you give an example of a material fact regarding a risk that an insured could argue the insurer ought to have been aware of without their express disclosure?
Yes. So what the insurer ought to be aware of is, what the Act says that an insured need not disclose what the insurer ought to be aware of, or what it is presumed to know. And it ought to be aware of information which people in its organisation should have passed on to him, and or information which is, I think the test is accessible and readily available to it. So what they're really thinking of, because the test of the insurer's knowledge focuses on what the underwriter knew, the underwriter is expected to do a bit more work and look into his databases. So the obvious example is what is in a recent claims file. Probably an insurer ought to know what is in a recent claims file if he had insured that risk before, for example. Similarly, he ought probably to know information provided to his assistant, for example. But he need not, he probably won't be deemed to have ought to have known information provided to a completely different person in a different department.
Okay, thank you. Another question we've got, this one's regarding co-insurance. If one insurer asks questions, does the insured or the broker have a duty to disclose the answers to the other insurers?
That is a good question, which I would like to give a bit more thought to, if I may. But obviously, the information provided to one insurer, this should be true. So to that extent, it would be better if the answers given to insurers were consistent. But I would like to come back to you on that question in more detail, if I may.
Thank you. We'll come back to you. We've got a record of that question there. We'll come back after this. I've got a further couple of questions here. We've got claims related question. Is it a legal requirement for a broker in the context of a claim to release all documentation provided by the insured to insurers, even where certain documentation has not been requested by insurers?
Well, thank you for the question, Tom. I think possibly that's outside the scope of today's topic, which is about fair presentation of risk. But there are some rules relating to your question, and again, I'm happy to circle back and discuss those with you afterwards.
Thank you. And we've got a final question here as well. With new ways of working, most people working from home impact on information gathering for presentations.
Well, that is also a good question. I'm not sure there's a simple answer to it. Certainly the law has not changed because people are working at home. The duties remain the same. I suppose maybe brokers who have been used to giving face-to-face presentations in the Lloyd's market, for example, where they can physically discuss a risk and point to documents at the box, might now wish to give much more thought as to how they electronically organise their files, because the duty remains that they should be giving fair and accessible presentations. So maybe there are software packages that can help signpost and package relevant volumes of documents.
Thanks for that, Andrew. I think that's the last question that we've had. So unless there are any more questions, I'll just pass it over to you to close the webinar, Andrew. Thanks very much, everyone.
Well, thank you very much for listening. the second part of this talk will be, second part of this topic will really be delivered by Neil Howes next week, who is going to discuss what happens if the duty of fair presentation has been breached. Thank you all for your time this morning. We're happy to take any questions. Please do message me on LinkedIn or email me or contact me by whatever means you wish. But have a good morning. Thank you.